Hello everyone, thank you for joining us today. My name is Shannon O'Connor and I'd like to welcome you to our Family Law Insider webinar on assets and family law during separation. So during today's 1 hour webinar, you will hear from specialists from both sides of the financial spectrum. Firstly, you'll be hearing from myself. I'm a senior manager in the Restructuring and Recovery team in Perth. To help guide clients that may be experiencing financial difficulties or facing bankruptcy, I will be discussing indicators of insolvency for individuals and companies, what bankruptcy is and how it can affect family law proceedings, and also touching on some recent personal insolvency statistics. I will then hand you over to my colleague, Simon Robinson, who is a financial advisor in our Sydney Financial Services team. If you have a client that has assets they are looking to utilise, Simon will be examining taking stock post-separation or death, the importance of structuring your client's situation, and building and protecting your client's wealth. Throughout today's presentation, you'll be able to ask questions by entering them into the Q&A box, which you should see at the top of the bottom of your screen. Please enter your questions as they arise during the presentation, and we'll be answering those questions at the end of the presentation. Before I begin, I want to let you all know about our Family Law Insider newsletter. This is released quarterly and is packed with all the latest news and issues impacting the world of family law. For previous editions of this newsletter and to subscribe for future editions, please head over to our website, which is rsm.com.au, and search for our Family Law page. We have family RSM team members throughout Australia writing articles for that one. Right, let's begin. So when it comes to separating, no two cases are the same. Some clients have assets that they are looking to grow or protect, while others may be under financial hardship and considering engaging an insolvency specialist. Whatever the situation your client is facing, it is important to understand what options are available and how you can guide them to get the best possible outcomes, and also to identify when the help of an advisor that is in either side of the financial spectrum would be useful to your client. So we thought we'd get the more sad one out of the way first and end on a more exciting note. So we're looking at family law and insolvency. So I'm like I said, a senior manager in our Perth team, and I specialise in managing the bankrupt estates in my team under the registered trustee, Greg Dudley. So my day-to-day is predominantly looking at bankruptcies and dealing with those individuals that are dealing with financial hardship. I've been in the insolvency industry. I've also done corporate insolvency. I've been in the industry for over 10 years now. So seen a lot of different varieties of things in my experience. So obviously no one wants their clients to go into financial difficulties, but it happens, and it happens a lot more than people think. It's important to identify the financial difficulties and act quickly. The earlier, the better. We find that when people are coming to see us, whether that's relating to their business or as an individual, they are coming at a time where it's a lot more difficult for us to advise anything other than a formal insolvency appointment. If they had kind of looked at the indicators or had an advisor around them that has kind of reached out to them and seen those indicators, and a few of them becoming more and more prevalent, at that point, if they're then going to see an insolvency specialist, that's when we have the best chance of being able to provide another option to your clients in terms of either being able to kind of turn around a business, or say for an individual liaising with creditors to try and reach an informal agreement without that formal act of bankruptcy having to occur. So in terms of the indicators, not one or two indicators may be a definite cause for concern and insolvency of that business, but the more they tend to add up and accumulate, the more and more concerned that the company is struggling at and may be insolvent. The indicators are more for businesses in whatever structure. So whether that's under a trust, a company, or an individual trading as a sole trader or as a partnership with someone else. In terms of individuals and the indicators of insolvency, they're a lot smaller, and they just relate to kind of looking at an asset and liability base and whether the individual's wealth is sufficient to pay their creditors as and when they fall due. So in terms of businesses, what the main things to look out for are ongoing losses, poor cash flow, absence of a business plan, incomplete financial records, or a lack of cash flow forecasts and other budgets. So it's the business is not looking back, is not doing the work to see how the business has performed up to date, but then also not looking forward and seeing what kind of revenue they need to be getting into to meet those expenses and not budgeting. It's very common that we see that the management accounts for a business, they haven't been updated for a good few months at least. And the director or the business owners really don't know the state of the business at currently, how it's historically traded, and then also how they expect it to trade in the future. In terms of increasing debt, that's a big sign of potential insolvency. So the liabilities are increasing and becoming more and more greater than the assets of the business. And that can be looked at on an individual basis as well, like I said. Another common thing we find is that there's problems selling stock or collecting debts, and with that stock, that it's obsolete. So we'll go into a business once it's closed down and look at realising that stock, and the stock that they do have sitting there has sat there for a number of months, and they're just not being able to turn that around in the right time frame. Another one we often see is unrecoverable loans to related parties, so that the director and their relatives are siphoning funds from the entity as a related party loan and not having that capacity to repay the loan, so effectively living off the income of that business. Creditors being paid outside of unusual terms, so if the business has a trend of paying at a certain point and that trend then shifts and they're not being able to pay within the terms that the creditors are prescribing, that is also a potential indicator. Continuing on in terms of indicators, so we have obviously suppliers and creditors starting to take action to seek recovery. So you'll see letters of demand, summonses, judgments being issued to the company or to the individual. Also being put on cash on delivery terms, that shows that the supplier no longer has faith in that business, that they will be able to pay on accredit terms and wanting to be paid up front. Issuing post-dated checks, quite often we'll also see checks written out, kind of sitting in a drawer somewhere waiting for the funds to be available to pay. Special arrangements with selected creditors, so that includes the ATO. I'd say the most prevalent one is the ATO, so reaching a payment arrangement. Like I said before, that's potentially not a definite cause of insolvency, but it is a concern that the business individual is not being able to pay the debt when it's becoming due. Hitting the overdraft limit, quite often see that overdraft limit kind of sits at that amount and doesn't get less, sometimes goes over. And that flows through into obtaining finance. So struggling to get the finance, changing a bank or lender, or the financier is becoming more and more involved in the business itself. And then on the flip side of that is dealing with kind of shareholder financing and not being able to source any further funds from the shareholders of the company. Another major one we see is in relation to payment of tax liabilities and lodgements. They'll become more and more outstanding, so not completing BAS, not doing income tax returns, and then also not making payments of those debts. Quite often find that the ATO is the biggest source of finance for a business because they're the easiest one to not pay, and especially now in the time we're living in with COVID, the ATO is not really taking any action. So we're finding that a lot of people are just then choosing not to pay the ATO and paying those creditors who are speaking up. You'll also find there'll become internal disputes. board disputes, director disputes, resignations, and also loss of key personnel in the business. And that there's also connecting to relationship disputes outside of that. So we'll find is quite often linked to business company failure, individual financial difficulties. We'll also have a family law matter on the side, hence the reason for my part of the presentation. Suppliers start complaining, the quality of work has significantly dropped, and there's issues with recoverability of those debts with customers. Another one we see quite a lot is an expectation that the next biggest job, sale or contract will save the business. So looking at the revenue of the next job to pay the liabilities of the previous job is not the best way, and is quite an important kind of indicator that there may be some inherent issues in the way that business is being run. That leads on to bankruptcy and what it is. Bankruptcy is a process available to individuals. It's not related to companies. So companies, their process is to go into liquidation. Individuals go bankrupt. It's a process for when people are unable to pay their debts as and when they fall due. There are a number of other formal insolvency agreements that can be dealt with. The first is called a personal insolvency agreement, and the other is called a debt agreement. And there are other formal arrangements and acts of bankruptcy that an individual can go under. They're more arrangements to pay creditors a certain amount. Debt agreements are on the smaller side, so with an individual with a smaller income, asset and liability base. Personal insolvency agreements are for those bigger scale arrangements being made with creditors. There are two ways a person can go bankrupt. So the first one is they can voluntarily petition for their bankruptcy. It's called a debtor's petition, and they can also be made bankrupt via a creditor, and that's called a creditor's petition. So we can accept appointments to administer a bankrupt estate either way. We can consent to act through a creditor, and a creditor can lodge that with the court. And then if the person is made bankrupt via a sequestration order, then that order will also provide for the appointment of the trustee. We can also have the individuals themselves reach out to us, and we can lodge their petition forms along with the trustee's consent to then administer that bankrupt estate. The main difference between the two types of bankruptcy in terms of a voluntary or a forced is the statement of affairs lodgement. So if you petition for your own bankruptcy, you lodge that form at the time of the petition. If you're made bankrupt, then that triggers the requirement to lodge a statement of affairs. And bankruptcy typically lasts 3 years and 1 day from the statement of affairs being lodged, unless the bankruptcy is being extended for non-compliance. So bankruptcy releases the person from most debts. It provides release and allows the person to make a fresh start. It's not meant to be punitive, and the Act is not created in a way that tries to punish an individual for not paying their debts. There are obviously sections of the Act that react to non-compliance of an individual, and if there are any kind of untoward or criminal acts that the individual has done, then obviously they may be penalised in that. But it's generally to be able to effectively draw a line in the sand and move forward. The key thing is it releases from most debts. So there are some debts that a bankrupt is not released from. And for the purposes of this presentation, I think the most important one to flag is child support, child maintenance, and spousal maintenance. These debts are provable though. So the debt can be proved in the bankruptcy, and a dividend can be received if there are sufficient funds. But the debt can be pursued during the bankruptcy and after the bankruptcy period. So there'll only need to be an adjustment if a dividend is received to reduce it by that amount. But otherwise, the debt can still be pursued by that individual who's owed the child support, maintenance, or spousal maintenance. So I'd say there's four main areas of the role of a bankruptcy trustee. So this is kind of predominantly what I work on a day-to-day basis. So they are assets, income, creditors, and investigations. So in terms of assets, we identify, collect, and realise the divisible assets of the bankrupt estate. I'd say the easiest way to think of it is that everything is a divisible asset unless it's excluded. There are a number of exclusions that are prescribed in the Bankruptcy Act, and I'd say the most common and most known ones are motor vehicles below a certain threshold, which is indexed. The current amount is $8,150. Tools of trade, the same, it's below a certain threshold, which is currently $3,800. Super, provided that there's been no transfers into that fund to defeat creditors. So it's just the super that's accumulated over the ordinary course. We've found that sometimes someone might put their cash into the super fund thinking that it'll be protected, but there are provisions to claw that back. Property held on trust, life insurance policies of a bankrupt or their spouse, and also the right of a bankrupt for personal injury and work done and wrong done to the bankrupt or spouse and the subsequent compensation received. And if these funds are then used to purchase a potential divisible asset, that protection also goes to that asset. So it's not available in the bankrupt estate. In terms of divisible assets, there's also after acquired property. So that is the assets acquired by the bankrupt or devolved on the bankrupt during the bankruptcy period. I'd say the most common ones of those are inheritances, and then also any kind of winnings, so lottery and such would fall into the bankrupt estate. The second one is income assessment. So we annually assess a bankrupt's income. If their income is over a prescribed amount, then they're required to pay 50% of that difference to their estate. The amount, the prescribed amount increases per the number of dependents of the individual. The amount for no dependents is $60,515 currently. Again, that amount is indexed and it goes up per number of dependents. So we're constantly looking at a bankrupt's income, doing a calculation of the net amount they're receiving, and then working out how much they need to be paying to their estate. If they're not required to pay income contributions, if there are no divisible assets, then there are no realisation and there are no recoveries in the estate, then that is how the estate is dealt with. The debts that can be extinguished are extinguished and the individual moves forward. The third one is dealing with creditors. So that's liaising with creditors, reporting to creditors, and distributing to creditors if there's sufficient funds in the bankrupt estate to do so. And finally is conducting investigations. So that's looking at what has happened in the financial affairs of the individual leading up to the date of bankruptcy and looking if there's any recoveries that exist. So I previously touched on super and payments to super. So that's one that we look at and see if there's any recoverable funds. The other ones are any preference payments to creditors. They've been preferred over another. More commonly seen in related parties where individuals have wanted to kind of pay off a mother or a brother before going bankrupt just to deal with that debt can potentially be recoverable. And also transfers for lesser value. So transfers for love and affection to related parties is a common one in that. And we can look at potentially clawing that back provided pursuant to sections of the Bankruptcy Act. That leads me to talking about family law proceedings and how the two interact. Like I said, it's becoming more and more prevalent that when I'm dealing with a bankrupt estate, there's also a relationship breakdown and a separation between the parties. And we're having to deal with family lawyers in that respect. So in terms of the way it works, there is effectively three potential parties in the proceedings. The bankruptcy trustee doesn't automatically become the party in the proceedings. It's different to most of the other proceedings that a bankruptcy trustee may deal with. The proceedings themselves are still between the non-bankrupt spouse and the bankrupt spouse. And the trustee is kind of on the outskirts dealing with the divisible assets. So the important thing is to identify in the asset pool those assets that are the divisible assets, and liaise and deal with the bankruptcy trustee for those divisible assets, and then deal with the bankrupt spouse or their representative for the exempt assets, and any maintenance that they're dealing with. The main exempt asset that we look at is probably the super and the super splitting between the parties. So that is something to deal with the bankrupt spouse's representatives. With regard to the divisible assets, the court determines the competing rights of the creditors and the non-bankrupt spouse. So just because a bankruptcy trustee is appointed doesn't mean the court won't order that a higher percentage is to go to the non-bankrupt spouse. And the court can also order that the trustee has to transfer divisible assets to that non-bankrupt spouse. So that leads me to a few kind of tips for dealing with a bankruptcy trustee. And these are more how I would deal with a family law matter, but I think they run true of probably most bankruptcy trustees. So in terms of insolvency practitioners, obviously we're independent and we're very commercial in the way we deal with recovery. So it makes it easier in that respect dealing with the trustee, because they're just looking at the creditors of the estate and the divisible asset pool and what is a commercial outcome that the trustee could accept. So we're looking for more likely a settlement to be reached between the parties as opposed to going to a trial. And in any settlement that we are looking to reach, we will consider the costs of pursuing that further. So in some ways, it does make it more complicated when a bankruptcy trustee becomes involved, but also easier that in terms of the negotiation for divisible assets, the emotion from that side at least has been removed, and it's purely kind of a business consideration. In terms of when a bankruptcy has occurred, providing ongoing notification and actively engaging with the trustee is important. You want to be making sure you're dealing with the right person. So if you're dealing with and negotiating with the bankrupt spouse regarding their divisible assets, then that's a lot of time wasted dealing with someone who actually doesn't have the right to be dealing with those assets anymore. Our experience is we will try and avoid being joined to proceedings and kind of sit on the outskirts and kind of try and deal with it in a settlement style. So we will kind of talk to the parties, work out what, try and reach an agreement. And also then if the orders are made and by consent, then kind of the courts are happy, at least in our experience, just to receive a written confirmation from us that we are happy with those orders that are being made. And usually they will include a certain amount to be distributed to the bankrupt estate. Bankruptcy trustees are only really interested in those proceedings if there are divisible assets. So if the parties are only talking about how super is going to be split, then the trustee won't likely be involved because super is an exempt asset and there's no recovery for a bankrupt estate, no matter where the super goes. So the other side of family law proceedings we look at is when an agreement has been reached prior to the date of bankruptcy and we're looking back and seeing what has previously happened. So the main thing we'll be looking at is kind of what the asset pool was and how it's been split. Also looking at the orders made and the considerations made at the time, what the creditors were at the time, and the particular section of the Act that's up on your screen is the one that we could potentially use. So if we believed that the orders being made were with an intent to defeat creditors of the bankrupt spouse, then we would use that to potentially set aside the orders being made and seek to recover some assets from the non-bankrupt spouse. Again, like I said before, bankruptcy trustees are very commercial, so it has to be a fairly material difference for them to commence and take action to recover an amount that they believe should be due to the bankrupt estate. More likely than not, I find, is we're looking at previous family court orders, and if they're generally within the reasonable amount, and at the time there wasn't any kind of creditor issues, then we're just kind of looking at them and going, yeah, they look reasonable, and there's no material interest in that. Finally, I wanted to touch on some annual statistics, and this is for all personal insolvency, so bankruptcy, debt agreements, and personal insolvency arrangements. These statistics are published by AFSA, which is the governing body for personal insolvency, so they're effectively the ASIC of personal insolvency. I just wanted to quickly point out kind of the trend that has happened, and this is by state in the last 3 financial years. I find kind of when I'm speaking to people, there is a big expectation that insolvency has ramped up. There's a lot, because obviously, given the current climate, people are struggling. But because of the grants, the job seeker, job keeper, we're finding that people are not being forced into insolvency, being forced into a formal appointment, whether that be a company or personally, that they don't have that trigger point. The main trigger point is probably, I'd say, the ATO, in my opinion, and the ATO are not taking as much action at the moment in respect of recovering debts. I think once that action and the banks ramp up, then we might see a few more personal insolvency, corporate insolvency activity. But I just wanted to throw that slide in, because I think it's quite an interesting one, because it's quite often completely different to what we would expect in the circumstances. And that concludes my part of the slides. I'll pass over to Simon, who will be talking about the more fun side of the financial spectrum. Thanks, Simon.
Great, thanks, Shannon. Guys, what I'll be talking about today essentially is separation and planning. Now, separation could be a family breakdown, or it could be the passing of an individual. So it's really important to understand where or what the process looks like and how we can help along the way, the key considerations for any separation. So do encourage questions along the way. I've kept this pretty high level, so if you do have any questions along the way, please feel free to reach out. The chat box is open and ready to go. Otherwise, we will dive straight in. So if that's going to move forward for me, there we go. Of course, everyone here as a legal professional will appreciate that I do need to have a general advice warning here. This is all general advice. If you'd like to discuss something specific about one of your clients or your own circumstances, please feel free to reach out and we can discuss it in more detail. First and foremost, whenever we're going through a separation, the key thing is understanding your client's situation. Now, you as a legal professional are in the prime position to understand the client situation. You're the one that's helping them understand where their assets are, you know, what they have out there, what is being taken into account for this separation, and the factors involved leading up to that. So you are in a prime position to understand the client's needs and current situation. Now, that will involve taking into account, you know, the assets that they have at the moment. So do they have cash? Do they have property that they need to split? Are there shares or other investments that need to be split? How are they held? Is it a joint holding? Is it, you know, most of the assets are held in the wife's name or the husband's name, whatever it might be. There are a number of reasons why you would have different structures in place. The property tenants in common. All of these things will come into play as to how we can set up the client situation and understand what's actually going on in their world. Superannuation is a key one as well. You know, if you've got husband and wife, and wife's maybe been at home looking after the kids for many years, superannuation is going to be a key asset in any separation. Is there an SMSF? Is there property within the SMSF? That is one that we see very, very regularly that causes problems for clients along the way. What do you do with that property and with that SMSF? So that becomes a significant item to discuss and understand before we can move forward with a separation. Control of that SMSF is obviously really important as well, particularly when it comes to death of a spouse or a partner. You know, it becomes absolutely critical, because who takes control of that SMSF and makes the decisions for the deceased spouse or for the fund in general, you know, it can be a huge problem. And the number of case law in Australia where this has become a problem, it is just endless. So it's really important that we understand the setup and the structure around the SMSF. Are there companies, are there trusts involved? You know, who's going to be the shareholder? How do you decide who maintains that company? Is there going to be an interest in that trust being maintained by both spouses, or is someone leaving? Is someone taking assets out of that trust or out of that company as part of the separation? What are the CGT requirements or the CGT consequences of those changes? All of those will become really important. And again, you are best placed to understand that. And finally, you've got the intangibles. So things like family dynamic. You know, is there another relationship involved? Are there kids involved? Stepchildren involved? You know, is one of the kids maybe disabled, for example? That might throw a different angle into how we or the position that the client's in and where we need to take them from a planning perspective. So it's really important to consider those as well. Who's going to be responsible for the kids going forward? You know, Shannon touched on spousal support, child support. All of those things will be really important in terms of understanding where the client is positioned now, pre-separation. So that is really important, and it comes back to as well, this is where you can start to set up for your client, ensuring that they do get a fair and reasonable settlement through this process. So, you know, a key example, superannuation is one that comes up all the time for me, and I've had one recently where the wife came to me for advice and said, look, I'm going through a separation. It's relatively amicable. Everything's going 50-50. We're going to sell the family home and I'm going to get cash and husband's going to keep their superannuation. Now I look at that and prima facie, it seems very reasonable. 50%, there's no capital gains issues. That seems fine. When you dig a little bit deeper, this client was in her late 60s. It wasn't working. So no ability to contribute to superannuation. She could potentially have half of that superannuation from her husband in a tax-free environment versus having earnings on the money that she receives from the property sale, then invested at marginal tax rates. So all of a sudden, the 50-50 is not quite 50-50. So that's where it's really important to understand the client situation, say, right, what do we need or what steps do we need to take to ensure that they do have a fair and reasonable separation? Again, as the legal professional, you are in the driver's seat. You are in that primary position to get the best understanding of that situation and help your clients work through that process. I'm not going to go through separation because you will all understand that incredibly well. That's not why I'm here to talk to you. So I'm going to skip through to taking stock. We've gone through the separation. It's settled. Whether it's gone through court, mediation, whatever it might be, you've got a clear settlement about where the client is now positioned post-settlement. What's next? Where does the client go from here? What we really need to focus on now is what are the client's needs and their goals. And this will be unique for each client you sit in front of. You know, they may be in a position where they really are starting from scratch through the settlement. And it is about going back and trying to work out how they're going to build up their super. Do they need to buy a house? Do they need to buy a car? You know, is this potentially the first time they're ever going to be living on a budget, depending on their situation? We really do need to start potentially from the ground up. Other clients, you know, they might come into more money than they've ever seen or know what to do with. Financial literacy is really important here as well. Does your client understand the complications that come with managing a significant level of wealth? Do they understand how to utilize a trust, an SMSF that they may have as a result of this separation? That's where the client needs become really, really important. We start with that. Then it becomes all about the client goals. What are they actually trying to achieve as part of this? Or what do they want to achieve? It might be that they say, look, I just want my house. I want a house. I don't want any debt. I just want that. And I want a car that's going to get me from A to B. Very simple needs from there. If so, great. That can make the planning process simple. If they want something a little bit more complex, or they have additional needs, I want a 5-star overseas holiday every year for 3 months at a time for the rest of my life. That obviously takes different steps and different requirements in the planning process. Depending on the level of wealth they have, what we're seeing more and more is people are looking at benevolent trusts or private ancillary funds because they want to give back in some way, shape or form. They can also be a nice tax write-off as well. So there are benefits there. That might be a key goal for your client. So understanding what is most important to them going forward will then help drive where the plan goes once we're in this new normal for them. And you know, that's where we help. The key thing for us as advisors is to draw those goals out for the client to help them verbalize that and really understand where the priorities are for them and what's most important. Once we've got that, we know the needs and we know the client's goals. The next step is to make sure that we have the legal framework in place that will ensure that they have that structure to make sure their wealth is efficiently managed. Taxes are correct. We've got the protection in place that's available through a trust or through super. Getting those legal structures right for what the client wants to achieve is critical. And again, that's where you guys as the legal professionals are so important to this structure. You drive so much of this plan about how we're going to get the best outcome for the client. Now, if we've got the client's needs really set in stone, and we've got a really good idea of what the client's goals are, that gives you such a powerful position to create the legal framework that will suit them. And then our role becomes utilizing that framework aligned with those client needs and goals to help drive those outcomes. So when I say legal framework, I mean, how are we going to set up the trust? Is it a family trust? Is it a unit trust? Is it a testamentary trust that we're looking at? Is it a disability trust? If it's an SMSF, who's the trustee? Is it corporate or is it individual? Is it are there binding nominations in place? Do we have wills? Do we have powers of attorney, guardianship, health directives? All of these things help to put that client in the best possible position to move forward and achieve their goals. And another key one is complexity is going to be really important in terms of, do we need the complexity for that client? A trust is a fantastic tool to be able to use to protect wealth, to manage wealth in a tax effective manner, to potentially help look after kids or relatives or whatever it might be. The asset protection side, I mean, talking about insolvency, a trust, not foolproof, but a great structure to potentially use to protect that wealth. Is it beyond the client's understanding? Is it too much for them to understand? Is it too much for them to manage? All of that comes into play. Because look, if we don't get that right, potentially there's the unintended outcomes. Do we cause unforeseen or unintended outcomes from a CGT perspective, from a stamp duty perspective? Do we open them up for future relationships to come in and potentially remove some of the wealth from the family? It is so important. You guys are in the driver's seat and we're here to help along that path. Now, just quickly on one of the key considerations it's amazing how often I have this conversation with clients, is all around, I don't want to pay more tax. So your tax position is going to be really important. And setting this up, whether it's a testamentary trust, a family trust, individual, whether you use a company, existing structures or new structures, this all comes into play. So the key things to consider here around tax is obviously an individual will be taxed at marginal tax rates. Now, if you've got someone who is inheriting, $100,000 and that's all they're receiving, and we're putting that to work, potentially an individual might be a reasonable way to hold that wealth and invest that wealth, because from a marginal tax rate perspective, if they had no other income, for example, they're unlikely to be paying tax at that point in their own name. But if we're talking about significant wealth, you may then want to look at a company or a trust or superannuation as the most effective outcome. Now, the example I used before, where the client was in pension phase, that's the most tax effective structure that you can use for a client. There are, of course, there's a catch in that you may not be able to access it immediately. So they're the things we need to weigh up when we're talking about planning for what's next. So they are key considerations, the tax side of things, and it will depend on where they are, what their goals are, and where they want to go. Building and protecting wealth as we move on. This is the part that everyone loves to talk about, right? So the key considerations when we're building wealth. Risk tolerance is absolutely critical when we're devising or designing an investment strategy for clients, because it's amazing how many people will sit across the desk from me and say, yep, I want double-digit returns, but I don't want to lose any money. Those things don't mix. Every decision that we make in terms of investment, there is a risk involved. Now, on the right-hand side there, I've given a few examples of different investments that you can make for clients. Cash, easy access, low returns is probably an overstatement given the current market. Dismal is a word that I've used a lot, but it's easily accessible, it is safe, it is secure, it's there. That can be very attractive for some clients. But if you're looking for double-digit returns, cash is not where you want to be. Term deposits, direct shares are there, but they each have different risks that you need to understand and be aware of. We have that discussion with clients to understand where they sit, how comfortable they are with seeing volatility. How would they feel if the market fell? COVID last year, 30% in a matter of 6 weeks. How do you feel at that point? It's really important because it can help set the scene for what their experience might look like and what is reasonable in terms of growing their wealth and achieving those goals. Time frame, incredibly important. If you've got someone who wants to buy a house in 6 months' time, the share market is not generally the place that you want to be, because you are putting wealth at risk by investing in the share market. COVID last year, 30% down in 6 weeks. That is not conducive to you saving for a house. So if you've got that short-term goal, you need to consider capital security, low risk, to make sure that you've got that money there for that specific purpose. If you are looking for how am I going to fund my wealth in retirement, then you've got a long-term time frame so you can take more risk. So time frame is key. Liquidity and income needs, absolutely crucial again. I had a prime example of this with a client recently. They have a superannuation fund, they're ready to retire, self-managed super fund, ready to retire. 2 million in the fund. And I said, yep, look, what do you need? What's important? How much do we need to fund out of super? It's going to be tax-free because there's 2 of you, so we're within the pension thresholds. Don't have to worry about tax. But how much income do you need? I said, Simon, I need 100,000 a year. On $2 million, reasonable, right? And then they said, but look, like all Australians, I really just want to own property. I want to go out and I want to buy 2 units, $1 million each with stamp duty and all the costs. And I just want that to be my retirement nest egg. And look, I'm an advisor in Sydney, so I'm never going to say don't invest in property. But the question for them was, all right, go out and buy $1 million property in Sydney. What's your rent? Oh, it's about 30 grand a year. Okay, so you've got 2 properties, 30 grand a year. Where are you getting the other 40 grand a year from that you need to retire? The strategy doesn't work for what they need. They need liquidity. The capital growth is there, but you can't go down the shops and buy bread and milk with capital growth. You can't sell off a room in a property. So that's where we have the conversation with the client, say, right, if you've got those liquidity needs, you need cash. You need something that you can sell down at a pinch. So that might be where we say, okay, great. 1 property, perfect. Let's go and do that. You've got your property, you've got the rent, you're comfortable there, that you can see, feel, touch your investment. The rest of the portfolio, we need to find something where we can go and sell 10 shares or 10 units in a managed fund, or we can wait for a term deposit to mature and use those proceeds to fund the shortfall in your income needs. So it's really important that we understand those liquidity needs, because it does get clients into trouble. That becomes really important as well, particularly, I'm seeing this more and more, superannuation funds with big properties in there. And all of a sudden, you need to sell that property at a pinch, or you run out of cash and it becomes an issue. So understanding the liquidity requirements is absolutely crucial. And then finally, protecting your wealth comes in 2 key forms. The first one is the structure that you put in place. That's where you can protect them from themselves, making not so great decisions, as people do when they potentially come into quite a bit of money. But it also protects them from others taking advantage of them. So the key thing there, testamentary trusts are a great one, where you can put in place that age limit and say, yes, you get this wealth on death, but you don't get it till you're 25 or 30. The highest I've seen is 55. Whether you want to go that far, I'll leave to you. You guys are the legal professionals, you know best. That structure is really important for that level of protection. And the other one is protecting from illness or injury. So client goes out, gets a big mortgage because they live in Sydney, and you have to have a big mortgage in Sydney. Protecting or covering that mortgage in the event of death, of total and permanent disablement, to ensure that they have a home over their head if they can't, a roof over their head, if they can't work. That becomes really critical. And when we understand their situation, we understand their goals, we can then work towards having an appropriate level of cover for them. So that becomes really critical. Income protection, of course, if they're working and they have to pay off the mortgage, income protection is critical. There's been huge changes in the income protection space over the last 12 months, more coming as of Friday. So that becomes really critical to review that and ensure it's still appropriate. Trauma cover, for example. Again, if you've got someone who inherits a couple of properties and they don't have a lot of cash handy, trauma cover is there to help with medical expenses, essentially. If you've got to go and see Dr. Charlie Teo and he charges you 100 grand to operate, do they have that cash available? If not, a trauma policy can help in that scenario. So we really round out that strategy to ensure that we've got the framework and we've got the strategy to build over a long term aligned with their goals, and we've got the structure and the floor in terms of personal insurance under their situation to make sure that if the unforeseen happens, we put them in a position where more than likely that financial situation will be protected. It's not foolproof. Again, you guys are lawyers, you will have seen, you will understand the loopholes where you can get in and out of these structures. But it's there. It gives our clients the best opportunity to protect that wealth. And that's me done, guys. I did keep that very high level. Just wanted to understand or help you understand more the process and some of the key traps and tips to help clients get the best outcome. So hopefully that was really helpful. please feel free to fire away with any questions, and feel free to get in touch if you do want to talk about a particular client, a situation, or you had any more specific questions that you wanted to talk about.
Alrighty. Thanks, Simon. We have a small amount of time now for questions. So if there's anything you'd like to know, type your questions in the Q&A box at the bottom of the screen and we can answer those. I don't think we have any at the moment, so we'll give a little bit of time if anyone has any questions.
We must have been really good, Shannon.
Yes, I guess that means we've done a good job in covering off those topics, Simon. So yeah, to everyone, if there's no questions, thank you very much for joining us today. Stay safe and we hope to have you back at our next Family Law Insider webinar. Thanks, everyone.